Good morning, this is your Kelso Report for Monday, November 21st, and I'm your host, Clark Kelso. We don't have any big news stories or cases today, we just have a series of one-liners. We begin in the area of government law and tort liability. In Stein versus Ryan, the Ninth Circuit, where we had the plaintiff suing the state of Arizona and individuals employed by the Arizona Department of Corrections for negligence and violations of the plaintiff's 14th and 8th Amendment rights. In 1997, the plaintiff pled guilty in an Arizona state court to attempted sexual contact with a minor, and the court suspended sentence, placed him on lifetime probation, in order that he spend 1 year in jail. He did not appeal. In 2006, he appeared in court to respond to a charge he had violated his probation, and the court revoked probation and sentenced him to 10 years in prisons. 3 years later, it was discovered that the original lifetime probation was an illegal sentence under the then applicable statutes, and he was released. He sued for damages for his 3 years of illegal confinement. The Ninth Circuit held that neither the Department of Corrections nor the employees of the department owed a duty to the plaintiff to confirm the legality of a sentence imposed by the court. They were entitled to act upon the sentence actually imposed. Accordingly, the Ninth Circuit held the district court correctly dismissed the plaintiff's state law tort claims, as well as his Section 1983 claims alleging constitutional violations. Next, in the area of criminal procedure, in People v. Voight, the 6th District rejected a defendant's attempt 4 months after pleading no contest to multiple charges of lewd and lascivious conduct with 3 minors, to withdraw his plea. When pleading no contest, the defendant conceded that the transcript of the preliminary hearing contained a factual basis for the pleas. 4 months later, the defendant sought to replace his counsel and withdraw his plea on the ground that there was not a factual basis for those pleas. The 6th District held that the defendant was estopped from making this argument, noting that by making a no-contest plea, the defendant generally waives all arguments relating to sufficiency of the evidence, and the bases for appellate jurisdiction are then limited to a small range of claims, such as whether the plea was knowing, voluntary, and intelligent. The claim that there was no factual basis for the plea was more like a sufficiency of the evidence argument, so the 6th District dismissed the appeal. Next, we have a habeas corpus case. In Ortiz versus Rebate, the Ninth Circuit rejected a federal habeas petition claiming that the defendant's confession was not voluntary because a polygrapher's empathic and parental demeanor and questions before the polygraph examination began resulted in the defendant's will being overborne by the polygrapher. The defendant had been properly given his Miranda warnings and had voluntarily agreed to take a polygraph exam. During the preparations for the exam, the defendant told the polygrapher he was very nervous. Well, in the course of trying to calm his nerves by telling the defendant that everything would be all right, he should just tell the truth for the benefit of his wife and children, and so on, the defendant then confessed the crime to the polygrapher and subsequently repeated the confession to investigators. The Ninth Circuit held that the California Court of Appeals, which had had a previous state habeas petition before it, made a reasonable decision in holding that a polygrapher's empathic and parental role during his or her instructions regarding the conduct of a polygraph examination did not create such a degree of psychological pressure that it rendered the defendant's confession involuntary. Next, an immigration law case in Lopez Cardona versus Holder, where the Ninth Circuit affirmed the Board of Immigration Appeals' conclusion that an alien convicted of residential burglary has been convicted of a crime of violence that is a, quote, particularly serious crime, close quote, which under federal statutes and regs makes the alien not only removable, but ineligible for asylum or withholding of removal. Next, an administrative law case involving LAFCOs. In Community Water Coalition versus Santa Cruz County Local Agency Formation Commission, the 6th District gave Section 56133 of the Government Code a practical, common-sense interpretation, so that an application to a local LAFCO to approve an agreement to permit a city or district to provide services beyond the city's or district's jurisdiction can be filed either by the city or district or by the entity that will receive the services. In this case, the University of California, Santa Cruz filed the application to approve an agreement between it and the city of Santa Cruz for water and sewer services. Opponents filed an action objecting on the ground that only the city was authorized to file the application, so the local LAFCO had no jurisdiction to act on the application. Well, the 6th District held that the LAFCO's jurisdiction did not depend upon who filed the application, but that it certainly was true that the city had to agree to provide the services in order for the LAFCO to decide to approve any agreement between the city and the university. Next, we have an attorney's fees case. In Vargas versus City of Salinas, the plaintiffs had sued the City of Salinas and its city manager for alleged misuse of public funds. The action was dismissed pursuant to an anti-SLAPP motion filed by the city, and the Court of Appeals and then the California Supreme Court both affirmed. Although their action was dismissed, the plaintiffs filed a motion for attorney's fees under Section 1021.5 of the CCP, the Private Attorney General statute, arguing that the Supreme Court had agreed with their legal analysis, even though it affirmed the dismissal of their action. Well, it is not surprising that the 6th District rejected this argument. When your action is dismissed on an anti-SLAPP motion, you are not the prevailing party. Pretty simple rule. The city also moved for attorney's fees under the anti-SLAPP statute, which has its own fees provision, and the trial court granted the city's motion. The plaintiffs argued that in order to protect a person's constitutional right to petition government, the government should not be able to secure an attorney's fees award against a private litigant, absent a finding that the suit was frivolous or a sham. The 6th District rejected this contention, noting that government has an interest in speaking out on issues of public concern, the interest under the anti-SLAPP statute, and in being free of the costs of defending meritless lawsuits aimed at infringing the government's free speech activities. According to the court, the fee-shifting provision in the anti-SLAPP statute furthers those legitimate government interests, and any chilling of petitioning activities is only incidental to the governmental interests the statute is designed to protect. Now, I think this is a very interesting constitutional argument, and given the prevalence of anti-SLAPP motions, we see lots of these coming up on appeal, I think we might well see the California Supreme Court grant review in this case on whether government entities can secure attorney's fees under the anti-SLAPP law. It's not that there's a conflict between the courts at this point, it's just an inherently interesting question that I think might attract the court's review. Well, that's it for today's Kelso Report. We'll see you tomorrow. Have a great day in the law.